Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am Executive Director and Vice President for Legal Studies here at Washington Legal Foundation. For those of you not familiar with the foundation, we're in our 45th year of free enterprise advocacy and education through litigation, publishing, communications such as this. I definitely encourage you to spend some time on our website at wlf.org if you'd like to get to know a little bit more about us. I have a lot to cover today, so I won't belabor who we are. This is the first program in a series of webinars WLF is hosting under the theme of taking the initiative on IP protection. Each program will be moderated, moderated discussion focused on businesses or an industry's use of strategic litigation, voluntary agreements, and other proactive initiatives to safeguard their intellectual property. Today's discussion focuses not only on trademark protection, but the connection between that protection and public health. Please be aware that this session is being recorded. If you experience any technical problems during the webinar, please let us know via the chat function. And if you have any questions for our panelists, please use the Q&A button on the Zoom webinar toolbar. I will first introduce our panelists. Give me a second here. Joined by Bill Childs, who's Assistant General Counsel, Director in the litigation group at 3M. He is involved in managing a range of litigation, including respirator/mask and fall protection litigation. Prior to the 3M, joining 3M in 2019, Bill was a partner at Bowman & Brook in Austin, Texas. He also previously served as a law professor at Western New England University School of Law for 8 years. And he practiced at Williams & Connolly and clerked for U.S. District Judge James M. Rosenbaum of the District Court for the District of Minnesota before that. Also joining us today is John Ursu. John is a partner with Faegre, Biddle, and Reath in the Minnesota office. He builds winning strategies in major cases. Over the past decade, John has handled matters at the heart of American life. These include defending Dominion voting systems in cases filed in Minnesota arising from the 2020 national election, arguing for the constitutionality of COVID vaccine mandates in the city of Northfield, and serving as court-appointed member of the Plaintiffs' Executive Committee in an MDL where he secured a $1.5 billion settlement on behalf of U.S. corn farmers. His cases have been featured in the Financial Times, Wall Street Journal, and USA Today. Crisis can bring out the worst in people. That has sadly been the case during the COVID-19 pandemic. In early 2020, personal protection equipment was in short supply and confusion reigned, two situations that create an environment that are ripe for profiteering and fraud. The supply of N95 respirators was not sufficient at that time to meet the overwhelming demand. Manufacturers, notably market leader 3M, were taking urgent action. But in addition to the pandemic conditions, 3M had another challenge. Offers began popping up on online sales platforms for actual 3M N95 masks or knockoffs at massively marked up prices. Government agencies and other regular purchasers of 3M masks were hearing from individuals claiming to be authorized 3M dealers with the promise of millions or even billions of respirators. In March of that year, 3M sent out bulletins to purchasers urging caution when dealing with anyone claiming to represent 3M on mask sales. It also reached out to federal and state law enforcement. Finally, the company put together a team that included legal department members. Ivan Fong, general counsel at the time, urged the in-house lawyers to devise legal strategies to take action against the profiteers and counterfeiters. Bill, can you tell us a little bit about the creation of that team? What complications did 3M face? What kind of things did you have to do to manage and overcome those challenges?
Yeah, I mean, you can imagine, and most of you can remember what the situation was like to be working in the spring of 2020. We were adjusting to working remotely when we were not accustomed to doing so. We were working very hard as a company to ramp up production. We dramatically increased the production of N95 respirators. And then we were also seeing an interesting mix of wrongdoers. At that point, there were some counterfeits, but not a lot. Mostly it was people claiming to have access to far more respirators than they possibly could, and claiming to have direct access to 3M respirators from people we knew not to be authorized distributors and who we thought was essentially impossible that they would be able to have the quantities they were talking about. So there were a number of things that the company did from the get-go, from the CEO down, there was a decision that we weren't going to increase the prices of the N95 respirators as a result of the pandemic. And that we were going to help give, pretty early on, we decided that we were going to give some guidance about what prices should be. Now that, what we put out was basically, here's roughly what you should expect as an end user if you're buying a single case of respirators. It wasn't exactly what the price is going to be, but at least gave you an order of magnitude. And it, ended up being $1 a respirator, ballpark, plus or minus, of course. And that gave people a lot of ideas, understanding of whether they were likely to be getting them from legitimate distributors or not. The reality is that there just weren't very many available at that time, and the demand was going, quite properly, essentially entirely to healthcare providers. And that was our main effort, was to do that and to try and reduce the amount of fraud in the marketplace. And I think that's a lot of what we're going to talk about today.
So once 3M decided to go on the legal offensive, why did price gouging and other profiteering behavior present especially challenging litigation hurdles for 3M, Bill?
Yeah, well, because mostly you can sell things for the price you want to sell them for, at least from a civil perspective. There's potential criminal liability, and we partnered with a lot of and continue to partner with a lot of government actors, with prosecutors and investigators and so on and so forth, about helping them go after that, but their resources were certainly limited. So once we were looking at price gouging, well, let me put it this way. As a general matter, we don't have the ability to control what somebody charges, but we can. We realized we did have some ability to pursue people who were doing things that we thought were improper in our name. So not just saying, I have 3M respirators for sale for $5 per 1820 or whatever, but instead we're saying, I'm a 3M authorized distributor. I'm getting these direct from 3M. There were people who claimed to have access to the valet desk at 3M, which is not a thing that exists. We only recently got free coffee. We do not have a valet desk. And so we thought, and there's some advantages to being kind of a dummy about this stuff, because it makes you come up with ideas that smarter people might sort of dismiss out of hand and say, well, that seems like it's harmful to our mark, as the rights in our trademark and all the rest as 3M, for people who are doing these things to be saying that they are part of 3M, affiliated with the 3M, an authorized distributor of 3M. And so working with John and a bunch of people throughout our preferred counsel network, we came up with a strategy to pursue it through trademark dilution. And we are aware of, and certainly we're aware of, the first sale doctrine, which says, if you buy a Toyota and you decide to sell it, you can say, I'm selling a Toyota, without, and Toyota can't go after you for that. But if you say, I bought a Toyota and I'm selling it and I am Toyota, well, then Toyota can stop you. And that was the kind of case that we went after.
John, 3M brought on Faegre Drinker to pursue some of these unique Lanham Act claims. Can you explain what elements a Lanham Act plaintiff alleging trademark infringement or trademark dilution has to plead, and how those elements sort of fit into what's happening or what's happening with 3M and its N95 respirators?
Yeah, absolutely. And I'll just say to begin how, like Bill said, we all remember what it was like and how very strange it was in the world and for us. And so I remember when Bill called me to say that they wanted to go after some of these folks, I was sitting on my girls' trampoline outside, trying to get some air. And, for the next 6 months, this is really what we did. And it was, I think, the most interesting broken field running I've seen from in-house counsel, because they had to go from doing nothing, right? I mean, they were doing all the things that we dealt with, moving out of their offices, everything else, and to pivot into a major plaintiff's IP firm effectively on a dime. It was amazing. And Bill identified early on that if there was a false affiliation, that created a trademark claim, and it might well give 3M standing to do things that it otherwise couldn't. And so the elements are and they're really similar both for trademark and for state unfair competition claims are, do you have a valid mark? And the 3M marks are valid and famous, and many courts have recognized that for a long time. And is it likely to cause customer confusion? And there's about a 5-point test with respect to customer confusion. We were often able to show actual customer confusion. And in the 2 cases that we pursued the most vigorously, procurement officials in Indiana, for instance, were, trying to save the lives of the hospital staff that were, dealing with all these folks coming into the hospital with a deadly condition for which there was very little, about which there was very little knowledge, and for which there were limited things they could do. And of course, if the hospital staff starts going down, it's hard to fathom how they could support the rest of the community. And so in one of those cases, a guy in, his Las Vegas hotel room, I believe, was claiming that he was, in effect, working with 3M, and that he was able to procure something like $14.5 billion worth of respirators, and it's entirely false. Yes, this is one of the emails that we ultimately used, and then ultimately turned over, of course, to law enforcement. Bill, do you want to walk through it?
Yeah, I mean, there was a whole range of these emails between the defendant who John and his firm ultimately sued on our behalf, and a very nice, very competent guy in Indiana, where he said, well, here, let me just go back a couple here so you can see the original email. I think I've got it here. Hi, we've got what I believe is a nice Easter gift for you in the state of Indiana. N95 from 3M at $282 each. And he says, it's overwhelming. This is very important, very busy. He didn't have any of these, to be very, very clear. And then the fellow from Indiana did an entirely reasonable thing of saying, nobody has worked in secrecy when we've actually gotten N95s. If there were millions of masks sitting anywhere, the federal government would go and get them. We suspect these aren't real. I mean, I think the Indiana representative thought that they were counterfeit. In fact, they just were fictional. And then the defendant got pretty obnoxious, saying, you're essentially calling me a liar. He was lying. So it was actually pretty accurate. And he said, against the counsel of executives from 3M to just forget it and move on. He's trying to help you out. No contact with 3M, no legitimate contact with 3M. So I just thought it was fairly bold. At one point, what was it that he called me, John? Like a potato peeler on the
submarine. So he said that Bill, that the guys that Mr. Puznak was dealing with were really high up folks, and that Bill was like the potato peeler on a submarine, and so he wouldn't know what's going on between Mr. Puznak and the C-suite. I think that was the point.
I think that's right. Yes.
Yeah.
So, go ahead.
And so, I mean, that's a good example of what it is. You'll note that we published the face of the defendant in that complaint. And part of this was to bring this stuff out of the shadows and into the light. This is, if to the extent that procurement officials were getting snared in this stuff, that was truly a life or death circumstance, and something for which the IP laws in the United States provided 3M with a remedy. And the harm to 3M plainly to its marks is one thing, but of course to receive a preliminary injunction and receive a TRO, both of which we got in that case, we have to show the public interest is affected as well, and that there's a kind of irreparable harm. And so so the law lined up nicely with the strangest set of circumstances where this product that 3M has made forever and had not been the subject of sort of this hot buying market, all of a sudden became, arguably the most valuable product in the world briefly. And for which there was a very limited supply. When our trademark lawyers looked at these cases, and we're trying to work through how we would assert them. I remember one of them said to me, well, the only problem for the defendants in these cases is the elements of trademark law. Otherwise, they might be okay. And so the elements of trademark law are, this is what it gets at. It just doesn't usually get at it in these circumstances. And so, you know, for me as outside counsel to see my friends and colleagues over there, you know, take the initiative and do so almost immediately in a way that would be very hard for most corporations to fathom. It really was a good example of corporate courage when it really, really mattered, right? If Hemingway's definition of courage is accurate, which would be grace under pressure, that is grace under pressure from my standpoint.
So by the end of 2020, there was about 20 lawsuits pending against fraudsters and profiteers. Bill, how did 3M choose which among those targets to sue out of the thousands of complaints that the company received?
Yeah, so it's a good question, and it was a sort of evolving set of circumstances. Early on, we were looking for. Well, let me back up for a second. One thing that John mentioned is absolutely accurate, that there was a lot more fraud out there than those 20 cases, and there were a lot more people claiming to have access. There was somebody who at one point said that he had a lot of 3 trillion respirators. And I actually somewhere still have a spreadsheet where I did the math, where you could just plug in what the claim was, and it would tell you, how many times the respirators would circumnavigate the globe, or how many times that many respirators would reach to and from the moon, just to have sort of these absurd numbers. So we were looking for cases where we could send a message, where we thought there was a particular type of behavior that we could use it to get a pretty clean win, and we had a lot of very clean wins, and where we thought there was particularly problematic conduct. So if they were pursuing healthcare providers, if they were, we also looked for geographic variability. And then over time, once we started seeing counterfeiting, we were pretty aggressive about going after counterfeit respirators as well. Because there you're, in the other settings, it's a real danger, but the danger is that you're wasting people's time and they're not going to get the products. In the case of counterfeits, you have no idea what's in that respirator. I have no idea if it's actually going to provide the level of protection in terms of reducing exposure to the particles of the relevant size. You have no idea if it's made from safe materials. So you have the possibility that is not just not helping, but that it is actually affirmatively harming. So especially early on, when we saw counterfeit claims, we were pursuing that. That's of course a different theory. There's a much more straightforward theory for pursuing counterfeit claims, but we still have some of those pending. But it was and then the third, or I don't know if it's the third factor. Another factor was sort of the volume of claims, and especially if they had gotten close to actually getting money out of anybody. One of the good parts is that for the most part, procurement people are caught on pretty quickly that there were a lot of scams out there, and were pretty good about waiting until they could actually see a respirator in their hands before they would pay money. But those were some of the factors. And some of it was leaning on people like John and other outside lawyers to give us a sense of how they thought the strength of the case was, and the rest of that. Are those most of the factors that you remember us thinking about, John?
Yeah, I mean, the real differentiator that I recall, because you're talking, just as you said, Glenn, about thousands of these coming to the 3M tip line, was a false affiliation. And so they would look, Bill in particular and that team looked very hard for a false affiliation. And then you said, I think at the time, particularly egregious conduct. And so a lot of this was egregious. And then so you're looking really at a new threshold. I recall, I can't remember if it's this case or another one, where they're talking about providing proof of life. In effect, that, if you put all of this money in escrow, vast sums of taxpayer money designed to save people's lives who are out there, putting their own, hide on the line in order to protect others. And the taxpayer, if the idea is just you need to put billions of dollars in escrow, and then we'll provide you, proof of life, which is a hostage term, right? That they'll actually show you these boxes. It was weird, and it made me. I learned something about people in the sense that I think people can rationalize almost anything. 3M's decision, which was to hold the line on pricing for these, ultimately gave an enormous opportunity to people who wanted to price gouge, right? And so if they could get people to, somehow or another put vast sums in escrow and then run around trying to find these respirators, they would pocket this enormous difference. And what a sad thing in a way. So anyway, the factors that I recall were good facts, right, for pursuing this, and a false affiliation, and something that would send a message in the marketplace that we're going after this stuff pretty hard.
Yeah, I would suggest, I thought of two other things to note. One is, and the other case that we'll talk about today, I think, is a good example where they claimed specific connections to executives at 3M. I call Ivan Fong to get help. Ivan was our GC at the time, or referring to our CEO or my colleague Haley, various people like that. And then the other thing that I always think back on in terms of the effectiveness of the message sending was there was a person who was talking to potential co-conspirators, basically, and we got the emails, and she said basically to be cautious because, and I believe the quote was, 3M has more lawyers than you do. And the word got out, and I do think we deterred some bad conduct, and I think we helped get the message out to procurement people that there are ways to find out if a provider is legitimate, and we had a pretty extensive hotline set up through amazing people in our legal operations group and elsewhere within the company to be able to help people figure out if they're actually buying from an authorized distributor.
So the first court to come down with a preliminary injunction in one of these cases was the performance supply case in the Southern District of New York. What was the rationale there that the court offered, Bill, and how did that ruling affect 3M's ongoing and future claims?
Yeah, I mean, it was all of the same rationales that John just described, right? It was a great opinion. That he also got criminally charged, that fellow. And speaking of learning something about people, I don't remember which model of car he said he was going to be able to buy, but I think it was a Ferrari in his text messages with his compatriots. It was a very clear case, and it was a very nice, and we worked with the folks at Mayor Brown on that sort of model for subsequent courts to say, here's a really straightforward analysis of each of these issues. Here's why it applies here, even though it's a kind of a unique approach to it. That's not the standard approach. To be fair, it's pretty easy if you're if it's a close question and you're a judge and it's a case where you're protecting people in a pandemic, it's kind of easy to lean towards the way of the people who are trying to help rather than the people who are trying to rip people off.
I think, and I'll just say that it's easier to feel that way in retrospect than it was at the time, right?
Yeah.
You never know, right? And the Constitution is not suspended in a crisis, and and judges have different views, especially on preliminary relief. And so our friends at Mayor Brown did a huge solid to everyone with the work that they did on that case.
Yeah, and I don't mean to suggest it was a layup by any means. We worked hard. We had to put together a good argument, and many of these the folks we were going after had good lawyers pushing back hard. And so I'm also definitely not saying that I think the judges did something that was legally improper. I fully think that our position on this was quite sound and quite supported, and we were careful to focus on those cases where there's false affiliation. If you're just out there price gouging, we're not happy with you, but we're not going to sue you for trademark dilution.
Right.
There had to be that plus factor.
And that's what sort of takes this out of a is this the free market running around sort of, pricing these respirators where they are? And the fact is these people didn't have respirators, right? They didn't. And so this is fraud, straight up fraud. And that is a different set of circumstances. It requires a different set of relief. I was surprised. I remember in the second case that we handled, how vigorously the defendant contested it. And even through the preliminary injunction phase, I think we said in our briefing that the theme of the opposition was effectively sorry, not sorry, right? and that there's a word to describe that sort of thinking, and the word is dangerous. And that's what they wanted to do, is go right back out and do it again. And these are folks who had suggested an affiliation with the Gates Foundation, suggested an affiliation with Elon Musk, suggested an affiliation with 3M, and suggested an affiliation with people that Bill and I know extremely well. And you can imagine how strange it is to receive recordings of folks out there in the marketplace trying to dupe others using your name. And so that's the level of wrongdoing that would sort of put something at the top of the stack.
I think that I was especially impressed with how workmanlike the judge's opinion was in the performance supply case, that she really went through all of the factors and did full analyses of each. But in the end, each of the conclusions was pretty obvious and straightforward, and she didn't skip any of the steps. So she really created a great precedent, I thought, for the other cases out there. John, why don't you talk a little bit more about the Starsiak case? That was the one that you were referring to, where the gentleman was claiming affiliations with the Gates Foundation and others. That really had some interesting and notorious facts in it.
Yeah, interesting and notorious, and I will describe what is in the pleadings and papers there, because of course the defendants in these cases don't like them. And so what we alleged there and had support that we also filed with the court in connection with these was that a former major, I believe, in the Marines was calling up 3M and saying that working with some of the most prominent charities in the world, trying to sell something like, or trying to give something like 1 billion respirators to underserved populations in Africa. And somehow or another, the lawyer for these folks got an email address for 3M's general counsel. And so 3M's general counsel is in the middle of this, the chief legal officer of this company in this crisis, dealing with emails coming from someone that he vaguely knows, suggesting that they're out there, that there's some legitimate charitable scheme going on that they need to be contributing to, and ultimately pushed them to Haley Schaffer, who was a lawyer and a colleague of Bill's, and immediately got 3M Global Security on the line. Around this time, we also received recordings from one of the victims of this fraud to the 3M hotline. And so they had, recordings of these people with pretty menacing and threatening conduct, in my view, as these folks asked again and again, do you have an affiliation with 3M? Are you associated with 3M? And they got very angry. And so it's, it definitely brought out the worst in folks. I will say, Mr. Starsiak, said till the very end, look, I was just trying to help. I wanted to try to bring people together and get these respirators out to people who needed them. But of course, he didn't have any respirators. It wasn't a legitimate channel, and he had no experience doing this sort of thing. And so, from his perspective, I think he thought I was just trying to help. And that goes to show, I think, how you can rationalize some pretty extraordinary behavior as alleged in the complaint and in the papers we filed in the court.
You had mentioned that in Mr. Starsiak pushed back a lot harder than Mr. Poznak did. But in both instances, you took depositions, correct? And,
Yeah.
seen that Mr. Sarsiak was far more competitive than Mr. Poznak was. What kind of defenses did Sarsiak put up there, and why weren't they successful?
Well, I mean, we had two different depositions of Mr. Starsiak, one of which was early on in the case when this was being hotly contested, and the other was part of our resolution of the case, in which he, like many other of the people involved in these, agreed to cooperate with law enforcement and tell us their story. And so, it's two different depositions. I think his defense was, I mean, it's twofold. There's one, he had a personal jurisdiction defense. He said I shouldn't be hailed into court in Minnesota. I'm in Utah. He had claimed, to be clear, that his world headquarters was in New York, on the Gold Coast, just down from Trump Tower, right? And so that was not true. And it was in fact in a 1.5-story rambler in, I think, Bountiful, Utah. And so this is pretty typical, which is effectively people trying to give a halo effect of legitimacy when they are in fact not legitimate. And so that was why I believe people affiliated themselves with 3M. They wanted to claim, in a way, legitimacy, so folks would be willing to put money in escrow. And Mr. Starsiak, the recordings at the beginning were saying things like, if memory serves, it could be an email too, I'm getting a runaround from 3M's escrow attorneys. Please help. And 3M, of course, has no escrow attorneys. We don't, that's not the sort of thing that 3M does, right? And so, lots of red flags went up. 3M Global Security has, former FBI agents and other folks there, really sophisticated folks. And ultimately they called the Gates Foundation and said, do you know these people? And the Gates Foundation said no. And so, this for these defendants was a big surprise. They did not want to be brought in these cases. And again, Mr. Starsiak defended vigorously and I believe, to this day, would say that he doesn't believe that he did something wrong. But 3M sure does. And we got a TRO in that case, and I'm confident we would have gotten a preliminary injunction if that had actually gone further. And so that's, it is what it is. And it goes again that, you can rationalize anything. And they did rationalize just about anything. That was, for me, Bill, the scariest of the cases we dealt with. You dealt with some pretty sinister stuff.
Yeah, I mean, it's interesting, and there probably could be a pretty good psychology paper on people who engage in that kind of activity and sort of how much they can justify for themselves. I do think some of them probably came into it thinking they were going to be able to do good work, and but there's sort of some magical thinking there, right? Where they think, okay, well, if somebody agrees to buy a bunch of respirators, they must exist somewhere. So I'm going to go. I'm going to get the money, and then I'll go and get them. And the reality is, they just didn't. Like we tripled our production. The people in our manufacturing are the genuine heroes. The level of work that they did to expand the factories. I got to go and visit our factory in South Dakota, and to see the expansion and how quickly that all got stood up was really, really remarkable. But a large expansion doesn't mean that there's suddenly magically going to be available to some guy in Las Vegas. We are good at distributing things, and we had the process through which those things were going to get distributed. And the level of self-delusion that I think a lot of people had, that, well, if I just have the money, I will be able to find them, was very strange.
One of the red flags that seemed to be out there with a lot of these kinds of cases where they were claiming affiliations with 3M was the number of masks that they claimed that they could provide. Could you talk a little bit about that, either of you, please?
Yeah, I mean, so the production, I don't remember exactly what numbers were made public when, but we made hundreds of millions of respirators prior to the pandemic, and increased that pretty substantially. But there wasn't going to be a single source where you're going to find 1 billion respirators or 2 billion respirators, or like I said, somebody claimed to have 3 trillion respirators. And remarkably, that person, one of my colleagues spoke with him, continued to believe that there really was a lot of 3 trillion respirators out there. Like there have not been that many N95 respirators made in the history of humankind. It is unlikely that they will. That's just an absurd quantity.
Nor are there enough humans to wear them, right? I mean, why?
Yeah, that would be a lifetime supply for everybody on Earth for a very, very long time. Yeah, so it was one of those things where it almost became a comical escalation of claims, and you could tell that a lot of well, I think there were a couple of different people for whom those claims were being made. One was for people like our friend in Indiana, who was a procurement person who could very quickly say, "Come on, that's insane. I know how many respirators exist in the world. I know how many humans there are in the world. You're claiming something stupid." But really, what I think a lot of that was aimed at other people in that marketplace who were trying to get themselves in between an ultimate buyer and a seller. And there were lots of people. I don't know if any of them ever actually made any money. I will be frank, because I don't think anybody ever actually had respirators in the first place, or very few of them did. But they would all try and get in the middle of that chain where they could add just a penny per respirator. Well, okay, penny per respirator profit on 1 million respirators. Decent little money if you never actually have to do anything besides introduce Bob to Mary, right? And I think it was for those people that they were making up these bizarre claims. But yeah, quite early on, I remember telling somebody it may well have been the guy in Indiana, if it starts with a B, it's absurd. If it starts with an M, it's probably absurd. It's not impossible that somebody had a warehouse with a few 100,000 respirators that they had stockpiled for some reason, but those got sold pretty quickly. And if it's 3M stuff, we know where they're going. And for a big chunk of the time, we were cooperating very closely with FEMA. I mean, we were always cooperating with FEMA, but there was a big chunk where they were effectively all going from places where we didn't really control where they were going. That was a long and convoluted sentence, but I think I landed where I wanted it to be.
I think it diagrammed out, if you needed to diagram it. With Mr. Puznak, who is the fellow in Las Vegas dealing with the Indiana procurement folks, I ultimately took his deposition in June of 2020. It was very strange. I mean, he's there in a mask, right? The videographer is there in a mask. It's all on Zoom. I mean, and he described, the world as he saw it, which with, bodies piled up like cordwood, right? And and this enormous public health crisis that existed in the world, and that he thought in the end, I said, "Are you like Ahab? Are you like Ahab going after the white whale with these respirators?" And he said, "I think I'm more like the Pequod. I think I'm more like the boat that they were on, that was trying to get home." And Mr. Puznak was ultimately sued also by the Indiana Attorney General. This was, I'm sure for him, a very painful set of experiences. And yet, if I had to, I will impose my view on the emails that Bill saw, which is effectively that people sort of thought that if you're flaming people on the internet, right, if you're shooting emails off and other types of things, that that maybe they weren't subject to the same standards that everything else is in the world. And those emails were really problematic because they weren't true.
So did the litigation for trademark infringement continue into 2021 at all? We've mostly been talking about cases that began and probably came to a conclusion in 2020. Are there any still going on?
Yeah, I think John's have all pretty much wrapped up at this point. We have a couple of cases that are still pending. I think some of those are still trademark cases. We do still have some counterfeiting claims. We've done partnered, and this is mostly my colleague Eva. I want to make sure credit goes where due, and Cheryl Hamilton also in our group, and a lot of other people at 3M. who have been very working really hard in the counterfeiting stuff. So we partnered a lot with U.S. Marshals and other law enforcement to seize hundreds of thousands, millions of counterfeit respirators. And again, don't know where they were made and don't know what they're made from. Unlikely to be effective at what they're supposed to be. And so some of those cases are still puttering along. And I believe some of the fraud ones are still kind of moving along, but mostly the fraud ones have wrapped up. The other thing I'll note is that, and I don't know what the total is, but proceeds that we've gotten from these lawsuits, we've all donated to COVID-related relief. This has not been something where we've taken the money and put it in the company pocket. It's been, I'm blanking on the name of the nonprofit we donated to, but there's a very good COVID-related nonprofit that we've used for proceeds from that.
One aspect of a lot of this action by 3M is especially interesting to us because some of our future programs in this series are going to focus on how IP owners can coordinate with sales platforms where their products are being counterfeited or infringed upon or copyright is being violated. Bill, can you talk a little bit about how 3M coordinated with some of those sales platforms to fight this?
Yeah, we've had some useful partnerships with a lot of the biggest names. One of the early cases that some of my former partners at Bowman & Brook helped us with, it was actually in Canada. And somebody had, it was a very early case, and somehow they'd gotten counterfeit N95 3M respirators from somewhere in Africa, if I remember right, is where they'd gotten them. And they were selling them at very high prices on a Shopify storefront. And once we sort of figured out what they needed to be able to comply with a subpoena, because they had some terms of use and privacy issues, very cooperative, very friendly, great to work with. Similarly, Amazon has been a good partner for us on counterfeit stuff in particular. I think it's to everybody's benefit in that sort of chain of commerce to work together to try and make sure that what is actually being sold there is legitimate.
It is an interesting parallel to, sort of ordinary trademark law, right? If you wander down the streets in Florence or Rome, you will, wander across a whole bunch of Gucci purses, right? Or, Louis Vuitton, bags and other types of things. And of course, that's not true, right? Those are,
what?
Yeah, I feel bad, Bill, because maybe if you got that for your wife, but yes, that is, and so this stuff happens out there in the world, but rarely with the kind of consequences, especially with respect to the quality, right? If a purse goes bad, it's just a purse. If a respirator goes bad, I can't remember what the numbers were early on in the pandemic in terms of the number of first responders who died, but it was a material number and terrifying. And so that's the harm that, in a way, that I think 3M was trying to address. I do, my recollection is that ultimately 3M's experience here was very valuable to the vaccine companies, and that the vaccine companies, had to figure out for themselves, now we have this product that is one of the, most important products in the world that everybody wants. And at least in the early days, it was harder to get. How do we protect it? And so, the learnings from this, from an IP standpoint, but also from a, what's the security of your supply chain, were very relevant to folks later on in the pandemic. If memory serves, Bill, we saw things like semi-trailers with respirators being pulled over in other countries, and the respirators being seized at borders. I mean, this was different in kind than I guess the purses in New York and Rome and Florence.
I think that's right. I always think back, we had a sort of a thank you to the network of firms and internal people who worked on this. And one of my best friends is an ER doctor out in Massachusetts at Bay State in Western Massachusetts. And he did a little video for us. He uses our oral line respirators, which is the what we use to expand it. And he did a wonderful video. He's got
well, those respirators did not exist pre-pandemic, right?
We were just starting to make them, but that was how we expanded a lot, was on those. And he that's what he used. And he's got 3 little kids. Well, I guess they're high school now, but kids a little bit younger than my kids and when we lived out in Massachusetts, we lived across the street and played together all the time. I visit with them all the time. And he did a little video for us standing outside his hospital next to an ambulance, talking about how knowing that he had legitimate 3M respirators on his face made him feel okay about going to the ER and then about going home to his kids. And it was a very sort of concrete example of what John's talking about. And sometimes it's easier to think about it in an individual way, to say, what I'm doing here is helping Aaron, right? Rather than helping this sort of vague world out there. And I think if people who are engaged in the fraud had thought more about who it was that they were ripping off individually, maybe it wouldn't have happened as much. I don't know. I think people can talk themselves into a lot.
So the litigation effort received a lot of public attention, a lot of press coverage. Was there a litigation communications aspect to the strategy, or was that more organic? Either way, how much do you think it contributed to the deterrent effect of bringing these suits in the first place?
Yeah, I'll talk about it a little bit, and then John can talk about it from the outside counsel position. We've got a great comms group at 3M, and we work very closely with them, thinking about what our goals were, which were, to deter and to get attention to the effort in order to make it so that people knew what they could do to find out if they were getting their products from a legitimate source, and also to scare off people from getting into this. And so we were quite intentional. My colleague Jen was a big part of that, Jen Ehrlich, and about sort of how to get that word out and how to get the information out. There was actually a book, I thought I had it right here, but that was published this year called Pandemic Inc. By David McSwain, a guy who I think used to be the Texas Tribune. Anyway, investigative reporter. And he talked, there's some things that I don't think quite got right, but he talked about the how quickly we were getting out there and sort of the effect that had on the market. And that reading that, it made me feel like, oh, that comm strategy did work. The attention got out there. And again, I go back to, I don't remember if I saved it anywhere, but go back to the person saying, I promise you 3M has more lawyers than you do. To me, read, okay, we're getting the message out. Does it stop everybody? No, but I feel like it absolutely stops some. What was your take on that whole process, John?
Well, I mean, the comms people at 3M were brilliant, I thought, and did a good job of getting a message out that was fair and true, and I think reflected the urgency of the situation. So I thought that was it was obviously a crucial part of the strategy. As lawyers, obviously we like to satisfy elements, but we also like things to be moral. And if they're not moral, my view on the way people make decisions is they won't do it. And so it was important in the Puznak case, and I'm looking at the press release 3M put out on when that case finally resolved. It was important to me that there be an apology. And here's the apology that Zach Puznak put out. He said, I would like to apologize to the state of Indiana, Luke Basso, and the people of 3M. If I understood then what I understood now, I never would have gotten involved in this scheme. I have testified under oath that the people who contacted me were attempting to take advantage of my best intentions and use me as a vehicle to commit fraud on the state of Indiana. Public officials and healthcare workers are the heroes in this important fight, and I am going to do what is necessary to make this right. I am cooperating and have turned over all my communications with the architects of this scheme to 3M, who will share them with law enforcement. I've also sat for a deposition to tell my story on the record to help educate public officials, healthcare administrators, and the general public to ensure that they do not fall victim to a similar scheme in the future. I'm committed to assisting 3M and law enforcement see justice served. The elements of a trademark claim are important. They're wise, right? They're reflected in statute. They're reflected in a lot of common law thinking. But in the end, when people do something wrong, they should apologize. And I think that the moral heft of 3M's work here did more work ultimately than the Lanham Act.
I did resist asking for a specific apology about the potato peeler thing.
I think that was wise. Yes.
Yeah.
John, you said during the presentation that this is the best broken field running that you'd ever seen from in-house counsel. What did you learn? What did the attorneys at Faegre learn during this experience that sort of carried over into other litigation, especially in crisis situations for you and the firm?
Yeah, I think it's to see things anew, right? In the sense that the law exists out there as a sort of sleepy thing that's on Westlaw. And my encouragement for many years to younger lawyers, I came out of a federal clerkship, Bill came out of a federal clerkship, but that you need more than a Westlaw account to be good at this, right? And that ultimately being a creative thinker is what makes the law go places. An old partner of mine once said, I was talking about a judicial opinion, how that it changed the law. And he said, judges don't change the law, we do. And I thought that is fair. And in this case, if people had thought about the Lanham Act, I think the way that they always had prior to the pandemic, this never would have happened. More people would have been defrauded, and I think more people would have died. And so Bill, in his other life, has a radio show and has for many years worked with different types of artists. And I think seeing the world that way helps. And it certainly helped us. I will not see crises in the same way again. And I also, it's not of any utility at all to be creative 6 months after the pandemic has become an endemic, right? It does nothing. To do it at the time when it's necessary, and to have the presence of mind to be creative and see things with fresh eyes is I think where good things happen. Bill, you said at the time maybe that this wouldn't have happened if you had been an IP lawyer, right? You came out of torts, where where there's a lot of different types of thinking, and that I think bringing that to this didn't hurt.
Yeah, I think that's right. And I think it is a sort of counsels in favor of having litigators who are litigators rather than in terribly narrow fields. And I understand why people specialize, and I certainly ended up specializing. But I very much valued that time when I started off at Williams & Connolly, where I did just a bizarre range of things, and the clerkship. I mean, we had one of the big cases that my judge handled when I was there was a trademark dilution case where there was a movie that ended up getting released under the name Drop Dead Gorgeous that was originally titled Dairy Queens. And so you could look up the opinion. There was an opinion issued where Dairy Queen, American Dairy Queen based in Minnesota, got an injunction against the movie being released as Dairy Queens. And you can agree with that or disagree with it, but it was an interesting case that I suspect had sort of percolated in my head for the intervening 20 years. So I think it's good to just sort of flail around and think about things and not always think that the way it has been done is the only way it can be.
And Bill, I'm sorry, John, go ahead.
No, I mean, to me, that emphasizes that if you're right, you're right. And if you're right, the law is wise, and it's designed to accommodate people who do things that are good and beneficial to society. And so when you're doing that, I think the law finds a way.
I imagine, Bill, that most of the litigation that you did while you were in private practice, you were on the right side of the V as a defendant, and as is unfortunately 3M most of the time. What did you learn, and what did your colleagues learn about being on the plaintiff side of lawsuits like this?
Yeah, so we certainly are almost always on the right side of the V rather than the left side of the V. It's kind of fun to be on the left side of the V. I'll say that obviously our fun was not the goal, but it was a pleasant side effect. I think mostly it sort of confirmed that, and this is a lesson that isn't limited to being on the left side of the V, that there's a place for creativity and for thinking about how to use strategies and doctrines that you haven't used before to see if there's a way to make it so you can advance your interests. Because I think we're right on most of the cases in which we're sued as well, of course. And as John said, most of the time the law tries to work for those who are right.
You know, my perspective is a little different. I have always been or often been a plaintiff's lawyer for large corporations. And, you know, in my sense, Glenn, I mean, you can either let the law come to you or you can go out and build it. And the courage of in-house lawyers who have gone out and said, look, I need to make a world where we can succeed because I think that what we're doing is good for the world. And I have seen that again and again and again, and including folks who took real risks with respect to their own career and otherwise because they thought they were right, and they were. And so, it's the best defense lawyers, of course, think like plaintiffs, right, as they're doing this the whole time. But to have the tools that the law gives plaintiffs is useful and meaningful for companies that want to extend their vision of the world out into further into the marketplace and into the common law.
Do not have any questions from outside viewers, so I guess we'll end on that very positive note. I want to thank you both for joining us today and kicking off our series here on sort of proactive IP protection. I think there's a lot of lessons that can be taken away from what 3M and especially what Faegre and Brinker did in this litigation. Thank you again for joining us today, and we'll definitely keep an eye on what you're both up to.
Yeah. Thank you so much for the invitation, Ben. It was a pleasure to chat with you.
Yeah, and thank you for your wise stewardship of this webinar, Glenn. It's been a lot of fun.
Thank you.